Thank you, Mr. Chairman. I hope that the opposition whip, when he's not detained by his Twitter feed, as are so many of us at this moment, took note of the brilliance of the speech by the Honourable Lady for Stratford and Urmston. She certainly, I think, laid out the most persuasive case so far for the opposition that has been made. And I hope, in just starting, I would refer to some comments made by the Honourable Gentleman for Hammersmith earlier when he said I'm a new member of the House. Indeed, he's right. And I have to say, the speed with which I'm losing the legal vote in Ipswich, I might remain a new member of the House. But in this, I hope I can offer this observation. He mentioned at one point, and I suddenly awoke, to a mention of the Golden Fleece, which was a myth derived from the Georgians of the ancient times, who used to sew lambskins together and pan for gold in the rushing waters of the Caucasian hills. And I tried the same with his speech. The muddy waters flowed down, and I filtered them with my hands, and little stuck to them, except for two things, it seemed: the general moan about finance, and then something else about access to justice, which went on and on and on, with nothing to enlighten this committee whatsoever, not in any way like the Honourable Lady who has just spoken. And he spoke for 3 hours. Now, many people on this side of the House and on that side wish to make substantial contributions to this committee's debate. We've heard one already from my honourable friend sitting to my right, the member for Swindon, which isn't entirely in line with what the government might be proposing at this moment. This is not a number of backbenchers who are going to stand up and defend everything in this bill and attack everything the opposition proposes. We are not like the previous government. We have many constructive suggestions to make, but all of us will have much less time to make that point, to discuss the issues held in this very important bill, and there's a second half to it which is revolutionary. If we are detained for this period of time with such enormous quantities of verbiage. Yes.
Can I suggest to him, as not a new member of the, can I suggest to him, as not as a new member of the House, that if you wouldn't have taken 5 minutes to make that contribution, he would have 5 minutes more to make his own contribution.
Yes. Well, I thank the Honourable Gentleman Chief, who was the Honourable Gentleman who was the Stoker-in-Chief of the Honourable Member for Hammersmith and his kind of never-ending railway train, smoky rail train. I will, yes.
If it helps, I think I meant Holy Grail rather than Golden Fleece. Does that help? And my mythology.
Well, I thank the Honourable Gentleman. He meant Holy Grail. I hoped it had been a curate's egg. I looked for the good bits, but I found none, but it was a bloody big egg. Anyways, we've now got to the core points of the Honourable Gentleman's objections to this bill, which are around finance, he made them out himself, and access to justice. And I'd just like to make some brief remarks about those key points, because I refrained from intervening too much on them. I thought it would be better just to try and encapsulate my remarks in a short intervention now. The Honourable Gentleman seems to think that we can discuss this matter outside the financial context in which we find ourselves. The fact is the country is bankrupt. If we do not make changes now, we will be coming back here. No, the Honourable Gentleman touched his head. We will be coming back here in 2016, and he may be the minister at that point. I hope not. But he will be coming back here to ask for more cuts to legal aid because the tough decisions have not been made now. And therefore, I heartily not only support but applaud my honourable friend, the Minister, for the very brave decisions he has made in trying to put together this bill, which nonetheless, and you wouldn't have known it from the doom-mongering from the members opposite, represents a cut of 16.7% to the legal aid bill. That is less than most other departments are having to endure in this spending round, and he has certainly defended the legal aid bill like some other ministers have not been willing to do for their own departments. So I'm impressed that we have managed to get here with a 16.7% cut. And the question now is, how is that distributed? But just within the context of the financial environment in which we find ourselves, it is interesting, and it was very telling, that out came the choice which the previous government made between criminal and civil legal aid. Now, the minister could have made a much easier decision. He could have said, we're going to cut criminal legal aid, because after all, criminals don't vote when they're in prison, and many of the people, I'm afraid, who end up in prison don't vote when they're outside prison. I wish they did. But that would have been the politically easy choice to have made, and it is precisely the choice that the previous government made. And in my mind, it was a terrible and catastrophic choice, which has meant that many people in the criminal system are at present not receiving the representation they require because of the poverty of representation afforded by current levels of criminal legal aid across the country. And I hope very much that when financial considerations allow, the government will first put investment into the criminal legal aid, criminal side of legal aid in a few years' time before returning to civil legal aid. And it is telling that the opposition's one idea in all this, one idea, we had no ideas about civil legal aid and how to find alternative savings. At least the Law Society made an attempt to make up some figures. The opposition came here with nothing apart from cut criminal legal aid. Cut legal aid from those who really are most vulnerable because they're about to lose their liberty, their reputation, and in many cases, their futures. And then we come back to this weird canard, which is hoisted by so many, you do hoist a canard, which was so many times in debates on public spending. And that is that we are cutting and therefore making cuts which will cost more money elsewhere. It is a weird argument about public expenditure that somehow if you spend more money, you will save it. And on that basis, we would be investing, or along the opposition's lines, in so many areas of public policy that there would be no money left at the end with which to spend. Do they not understand the lunacy of their argument, that somehow you need to spend money in order to save it? Because that is exactly and precisely the policy that they have attempted to pursue over the previous 13 years, and it has ended us up precisely where we are. We are talking about government cash, and government cash which must not be spent. And I'm afraid the Minister's proposals so far are the only ones on the table because they have had, bar a few helpful interventions from the member for Stretford and Lumsden and the Honourable Member for Swindon, there are no alternative proposals or any alterations which anyone has offered of any substance. And then we have the issue of access to justice, successfully blown apart and so elegantly by the Honourable Member for Swindon. That we are nowhere near the conception now of what legal aid meant in 1949. The number of marriages ending in divorce in 1949 was minuscule. We now have a situation where half of marriages end in divorce, and what's more, we are affording legal aid at every single stage of that process to people on low income. And yet to people on low incomes, as I was pointing out earlier, there is no recourse to legal aid at all if they are above the very mediocre threshold which is in place at present. Now, the Honourable Gentleman for Hammersmith says that he is not aware of this issue. That is precisely because there are tens of thousands of people across the country at present who know that they have no recourse to legal aid in their marriage disputes. And of course they're not going to come to him because they don't expect it. And yet that is the case, and he would know that anecdotally if he had his ear a little closer to the ground. The only people who can pursue their marriage interests or dissolution of their marriage to the courts are those with no money and those with huge amounts of money. And frankly, I think it is unjust on those earning very limited amounts of money, paying too much tax, in my view, at the moment, to the Exchequer, to have a part of that tax go to those people who are not earning, who would not be in the position, were they earning a bit of money, to pursue their marriage disputes through the courts. And then there's the idea that somehow we are taking out of scope a whole series of areas which have been dealt with previously through a generous legal aid system which is almost universal. But the fact is that there have been injustices or injustices done to people which could not be answered with legal aid right since the beginning. And I'm aware that I'm up against a far more interesting speaker over in Portcullis House, so I might as well use a topical example. And I think it is brave of the visitors in the gallery here. It's rather like getting the tickets for the volleyball in the Olympics. And the 100 metres final is going on at the other end of the stadium. But could I use some topical... Could I use some topical examples? Those people who have been victims of hacking, some of them in very vulnerable situations, some of them on low incomes, as we have now found out, would not have legal aid to be able to pursue their injustice through the courts. And even amongst ourselves, there are instances where there could be enormous injustices, which indeed change the nature of our democratic process. I mean, just imagine, perforce, that there were a candidate in an election who put out entirely specious literature, maybe about, I don't know, housing, saying that a whole group of people in the constituency are going to lose their houses if their opponent won that seat. Not only specious, but lying, mendacious, and I'm sure that would not apply to anyone in this room. Now imagine that such a situation occurred. I just finished my...
I think you ought to give way, because he's clearly referring to me, and he's just used the words lying and mendacious, and I think he possibly ought to withdraw them. I can amplify the point, because funnily enough, as he wouldn't know, the decision, the preliminary decision on selling an estate to a developer for demolition occupied by thousands of families took place on Monday evening in Hammersmith. I'd like him to withdraw that comment, A, because he's wrong, and B, because I think his comments are completely out of order, and his language also.
Thank you, Mr. Chair. I was certainly not withdrawing any comment. I was using a hypothetical situation where someone put out entirely specious literature which changed the course of an election by lying and frightening local residents. And those, and if I may just finish the point.
On a point of order, I think, the honourable gentleman, either he is making an entirely vacuous and spurious point, or he is making a reference to me, but does not have the courage to actually say that, and is using language which is unparliamentary and unnecessary. He should withdraw his comments on either basis.
I'm sorry, withdrawing the comment. If he'd allow me to finish, he would understand why it's not a vacuous point. Because neither those who felt that they had been unnecessarily frightened would have recourse to legal aid, nor the opponent, or any opponent which felt that they had been unfairly prejudiced. Rather, in the case of a case that did actually happen, as regarding the legal action taken by a Liberal Democrat loser, was unable to go to legal aid in order to fight their opponents. So in that case, even in the course of democracy, it is not possible to have recourse to legal aid in order to fight an injustice in a hypothetical situation. And then there are the issue of the international comparisons. Now I have to say that the Honourable Gentleman for Hull, who is sitting behind, and I are lucky enough to sit on the Justice Select Committee together, and we have heard the evidence of many academics who have come here and discussed the international comparisons. And it is entirely right that the figures that the government has put forward are the views of some academics. There are others who give different. But in every instance that we heard, actually the British system, when you agglomerate them together, comes out as either the most or second most expensive system in the world. I will indeed.
So the member speaks of international comparisons, and the honourable member for South West Norwich has been a great champion, this me being nice again to the people opposite, a great champion of the Canadian legal aid system, particularly during the evidence sessions. I wondered if the honourable member would share my interest in the Public Commission on Legal Aid, in the conclusion of the Commissioner, who said, based on the evidence presented to me, I cannot come to any conclusion other than the services provided in British Columbia today are too little, their longevity or consideration too uncertain. Whilst Mark Benton, the Executive Director of the Legal Services Society, said it doesn't meet the need and supports the conclusion, I've lost my place now, and supports the impression that the legal aid should be redesigned and it should become an essential public service and be better funded.
I thank the honourable gentleman, and the whip should write more clearly in future, because I have to say that in a moment when I was just losing the thread of the honourable member for Hammersmith's argument, I looked at his website, and there are 23 pages of press releases with which he is delighted the local media, not one of which refers to his own CAB. And I don't see anywhere any interest at all in law, order, or justice, or indeed legal aid. And it's interesting, therefore, he's suddenly kind of developed an interest in all of our positions on the CABs and law and order. I will indeed.
The reason for that is, I'm surprised if the honourable gentleman doesn't know that, but parliamentary websites paid for by the taxpayer cannot be used by honourable members when they're in their role as front bench spokespersons.
I'm glad the honourable lady charges the taxpayer for her website, because I actually don't, and I think it's not right to do so. And you can speak a lot about. No, actually. No, I wish I had more for my campaign. But in all seriousness, actually, I mean, of course you can put up local campaigns about CABs on parliamentary paid websites. I mean, absolutely. That's not the point. The issue, and there's always the kind of. I'm afraid the opposition don't really understand about fighting for local campaigns while supporting the government on its broad policy objectives. It's something they haven't quite understood, although the member for Salford did understand it in the previous government. Anyway, to get back to the international comparisons, the point about the international comparisons is that, frankly, most of the time, the British system, the English and Welsh system, does. Can I just finish the point for the Honourable, because I'm sure he's going to make an important point. Does come out top or near the top. And importantly, because this was raised in the evidence session of the committee, when you look at the difference that a inquisitorial system makes and one based on advocacy, as we have here, an adversarial-based system, it actually makes very little difference. And that was the evidence we heard in committee. So it's not the point that because we are adversarial, it is not because of any difference we have necessarily from our European partners. It is to do with scope, it is to do with cost of lawyers, that was brought out very clearly in the evidence we heard in the Justice Select Committee, and it's to do with massive inefficiencies in the system. And the government is trying to address itself to those three main issues, and I hope, therefore, that we can try and flesh those out a bit more in this committee. I will.
Very obliged to the honourable gentleman. I thought the Justice Select Committee, which him and I both are lucky enough to be members of, found that our expenditure is average across Europe. Am I not correct about that?
Yeah, that wasn't the experience that I understood when you're looking at legal aid costs, which is where we are second highest. And I think that was understood when we had the evidence sessions. Indeed, if you start to look at wider justice costs, which is very difficult to do for reasons that you understand, the Honourable Member understands, we are somewhere in the top quartile of global systems. But we're still high. And the important thing about this is that even after the cuts which are proposed by Her Majesty's government, we will still be in the top quartile of spenders on legal aid. And by the government's own reckoning, we will still be the second heaviest spender on legal aid in the world after Northern Ireland. Yes,
his arguments seem to be threefold. One is that the country's bankrupt, so that justifies any change that you want to implement. And I think that's a fair point, because it seems to be the general view of the government that it doesn't matter what the implications are, that they will hide behind the fact, and you said bankrupt, I don't know, it's news to me that this country's bankrupt. It's got a triple A rating. It's never had a problem with raising finances. So quite frankly, I'm surprised you would say that. The second thing is you use examples from around the world. I think you would accept that those examples are disputed left, right and centre by different academics, so it's you can't really tell whether that is the case or not. The comparisons can't be. We heard from witnesses last week that the comparisons that are being used by the government are challengeable and they're probably not correct. So I'd be interested to hear his view about why he believes the justification of the budget position means that we can do anything that we want.
I thank the honourable gentleman. He was making essentially 2 points. The broader issue about the financial situation of the country is that if we don't make tough decisions now, whoever will be conducting the next spending review will have to make even tougher decisions. without reverting to the discussions which I know he would want to have in another place at greater length. That is just the position of this government. It is the one on which both parties in this coalition won the last election. And you cannot but consider... It's a completely fair intervention by the member of Scotland. And to show that I'm capable of admitting that, under which both of us formed the coalition, having with a combined vote won something like over 50% of the vote. So even on the PR terms, we did well. But, look, no government has ever suggested, whether in defence or education or health, that somehow these were unlimited pots. And yet in this new clause, there is the provision that somehow the need for legal aid, as defined in a completely arbitrary manner as far as I can tell, trumps the resources available to supply it. And what I find odd if I could just finish the point, what I find odd about the opposition's argument is, on the one hand, they say, albeit rather quickly, we would agree to cuts in legal aid, and we would agree to them almost to the same extent, or perhaps even the same extent as the government is proposing. And yet, on the other, you are writing a blank cheque into the first line of the legislation, which says that need, as defined completely subjectively, trumps the resource issues which confront the government at the time, which is why I was trying to tease out of the honourable gentleman whether he had approval from the Chancellor, which he clearly has, Shadow Chancellor, which he clearly had not.
The Law Society have had much to say about the bill and its many faults, and even suggesting ways, in fact, that you could save that money. In the Honourable Member's Times article of the 15th of June, he actually dismisses the contributions of the Law Society as partisan attacks of bewigged scargills who are unlikely to get a hearing from the government. Does the Honourable Member find any good advice from the bewigged scargills of the Law Society?
I thank the Honourable Member for prompting me on that article, which has caused me rather more trouble than I had anticipated. But I was being very frank, actually, about who I felt was at fault here, and that was not the professionals themselves. I think there are many people, especially at the family bar, who are not earning a huge amount of money, who care passionately about what they're doing. They've been failed comprehensively by their trade unions, because they can't even agree between themselves as to the cuts that they were proposed. The cuts are largely... No, but they have no regulatory... Trade union... I will.
Very obliged. He described, I think, the Bar Council as a trade union, and I suspect the Law Society as a trade union. In similar ways, the Honourable Member for Broxton will recall the Health Bill Committee, which and I served on, when our honourable colleagues were describing the BMA in the same way. It's ridiculous to describe the Bar Council and the Law Society as trade unions.
The Honourable Gentleman is... The Honourable Gentleman makes a fair point to this extent, and I know he has a very worthy trade union background. If I can just finish the point. Trades unions, typically known, might have shown a rather greater degree of proficiency in arguing on behalf of their members than the ones in representing the legal profession. And the reason I call them trades unions is because now, over the last 10-15 years, they have lost their regulatory function. They do not disburse legal aid anymore. And consequently, their only function is to respond to their subscribers' lobbying efforts to protect their incomes and their sources of state funding. That is really the core purpose now of the Law Society and the Bar Council. They have functions, their other functions are now gone. And when you listen to their submissions, be aware that, frankly, they are responding only to one part of their membership. And I had a great deal of correspondence from solicitors who were very pleased with what I was saying about them, because they are failing now many of the people that they seek to represent. And the reason that I say that they failed them, and I'm just responding to the intervention by the Honourable Member for Stockton, was because those people who work hard, who care about the family law system, were failed by a group of people who could not agree between themselves, provided no substantive proposals of their own, and no constructive suggestions which were likely to go to anywhere near to making the savings that the government needs to make, and of the scale that Her Majesty's opposition supports. And that is why I chose to attack them like that. And if I could just bring in... I will. Give way to you.
I'd like to thank my honourable friend for giving way. I want to make one positive comment about the Law Society's proposals. Just one, which they put forward, which is they did make the point that we need to make the court process more efficient. And one of the things that we discovered from looking at our international comparisons is that the cost per case in Britain is very high compared to other countries. And I'm very pleased that the government is, for example, introducing email into all courts to speed up the process of transferring papers, where we have heard quite a lot of delays are caused by papers getting lost in the post or not turning up on time. So I think the Law Society did make a good point on that front. But the other element of a high cost per case is the high cost of lawyers in this country as well, and that is where they should look to their own organisation to find further savings.
I thank the Honourable Lady for that intervention. And if I can just go on to a further point of the Law Society's contribution, which is...
Thank you, Mr Alban. I'm interested as to whether the honourable member agrees with the intervention of his honourable friend.
I'm going to be jumping up and down at this rate rather a lot. I was going to come on to it in rather great detail, but I just wanted to kind of go there via talking about mediation, which is something that the opposition has talked about now at considerable length, especially the member for St Helens, and also in the submissions of the Law Society and the Bar Council. The fact is that we put more marriage cases through the courts in England and Wales than any other European country. And in Sweden and in Germany, which I tried to speak to witnesses about during the evidence session, almost every marriage case goes through mediation. So it can be done. Not only can it be done in some of the more progressive jurisdictions in the European Union. And I know that at the conclusion of that evidence, I got a withering look from the member for Stretford-Nurmston, which upset me greatly, because I respect her and I felt burnt by her reproach. And all I can say is I'll explain this, why I was angered by the evidence being given by the women's rights groups and the WI who giving evidence. And that is that this is a real opportunity now to sort out one of the considerable injustices in our legal system, which is putting women and families through terrible, protracted, sometimes vexatious legal disputes in the courts, which we all know from personal experience and from constituency work can do more damage to families and to individuals than the situation that they found themselves in before. And I will give way just in a second to the Honourable Lady. Here with mediation, we can actually create a situation which is geared towards reconciliation rather than division, which is the natural course of any court action. And I would hope, therefore, that the women's organisations that we saw in evidence would have done a bit more work, just to look at comparisons across Europe, to see what was working where, what could be suggested to the government to make this proposal really stick together, so we could take many more families out of the courts. And that was my frustration with what was given to us by the women's rights organisations. Yes, sorry, the lady. Yes.
I'm very grateful, and I do apologise to the honourable gentleman if he interpreted my look as withering. I certainly meant only to offer him a wry smile of encouragement, because...
I hate to see you angry.
Yes. Because I agree with him that, of course, we should seek to make as much use as possible of mediation wherever it is appropriate. But would he not agree with me that limiting it only to cases of domestic violence is actually too narrow a definition? And in cases where there's a high degree of conflict and a real mismatch of power in the relationship, mediation may be an inappropriate route.
Thank you, Honourable Lady. And there are certainly cases like that, and that is why the government, I hope, has beefed up its proposals with the discretionary fund for those cases which really can find no resolution through mediation. But members opposite must know that if there is the option of automatic automatic entrance into a court at the end of a mediation process, many people will just go through the mediation process. If they don't feel they got what they wanted, they will try and go to court as a last-ditch option. And so the mere fact of it existing there, as my honourable friend, the member for Broxtowe, was explaining earlier, can encourage litigation itself, when in fact mediation would have done a better job for both parties. I'll give the lady.
I'm grateful to the honourable gentleman for giving way. He's totally decontextualised his remarks. He hasn't begun to take account of the completely different provision in the welfare state in the other European countries as compared with this country. And furthermore, he hasn't understood that the pressure on people to win the best possible settlement which they can will have been further increased by the government's absurd notion that women should pay for the services of the Child Maintenance Commission.
The Honourable Lady forgets that Sweden boasts, and that's probably the wrong word, the highest rates of reported domestic violence in the world. And yet they can deal with mediation in almost all cases of marriage breakdown, whereas for some reason it's understood that we can't here. And all I'm doing is just trying to challenge the wisdom given to us by those groups who have a financial vested interest in keeping the status quo, that somehow mediation will not work, and that we must therefore continue with this adversarial system. I will. I'll give this.
I'm very grateful to the Honourable Member. I know we must make progress, but would the Honourable Member agree with me, or at least consider, that it is also very important that in order to mediate properly, it is often the case that you have to have legal advice, so that you go into the mediation process knowing what your rights are, knowing what the likelihood of success is given the assets in any marriage and so on.
I completely agree with my honourable friend, and so do members opposite, and therefore they agree with the government, who have provided advice in this bill for people going into mediation with legal aid. So I'm glad we found this moment of reconciliation between us in this way across the House. I think that the picture drawn up by the honourable member for Hammersmith of this wonderful real-life Michael Trenchard traipsed through the ecclesiastical courts is one that we will ourselves will laugh at in 100 years' time when we look back at how we treated families and marriage breakdown in the early part of the 21st century, because frankly it is barbaric and we need to move on to something far more humane. Mr. Hollowbone, I seriously not intended to speak at this length. I'm glad I excited members opposite to intervene on me so much. And I submit only, therefore, these three things. The first is that I hope that in discussing the amendments as they come through, we can actually find the concision that the honourable member for Stretford and Urmston found herself. I think, secondly, we have to set this in a financial context. And thirdly, please remember, all of us, that access to justice has been a very varied thing. And in fact, I'm going to conclude, if you don't mind. And if we are going to protect the rights of the most vulnerable, of women found in difficult situations, and families and children, actually mediation is a much more just way of proceeding in most cases.
I rise to support the amendments put forward by my honourable friend from Stretford and Urmston. But before I do that, I would like to refer to the suggestion from the honourable member from Swindon South of the block funding. Having worked with the Legal Services Commission, I absolutely agree that to get rid of some of their bureaucracy would be a good thing. However, block funding is not on the table. What is on the table is the removal of scope of social welfare law. If block funding was on the table first, I would be quite happy to look at that and possibly agree to the removal of the social welfare law. As it is not on the table, I can only deal with what is here. So I would like to argue that actually the removal of social welfare law from scope and it actually will increase the cost. We've heard a lot about high cost cases here, a lot about high cost of legal aid. And what I'd like to do, with thanks to Bolton CAB, is to just go through a few of the cases that people have been to them about and to demonstrate where the extra costs will come to the government. This is in the client's own words. My last visit to the CAB was to once again try and get disability living allowance. I have severe osteoarthritis, I could hardly walk. I was in extreme pain and was on 2 crutches. It costed me an absolute fortune in taxes. I spoke to one of their advisors, we filled in the forms, and after the third time of trying, I was awarded disability living allowance. If I hadn't received help from the CAB, I would have finished up in hospital with a nervous breakdown. I was at absolute breaking point with the system. I wouldn't say I was suicidal, but I was very close. Cost of that advice, £167. Cost of a suicide, nearly £1 million. I have another example as well for that. Excuse me while I find the relevant example. Here. I was at my wit's end. I couldn't sleep, eat. I was so depressed. I was ashamed. I couldn't tell my family. I was 65 years old, worked all my life, and I now just couldn't cope. I went into the bank to tell them again how I couldn't afford on my pension to make the payments they said I had to make. They advised me to go to the Citizens Advice Bureau. I did right away. They made me an appointment to see an advisor. Oh my God, the relief was wonderful. All the worry gone. They went through everything with me and worked out a plan. I'm 67 years old and I'm now in control of my money. I had really thought of taking some sleeping pills. I couldn't cope with the phone calls. I couldn't cope with the letters. I wasn't even answering my door. I used to pretend to be out and I sat in the dark. Cost of that advice, £200. Cost of the suicide, over £1,000. I needed help on a couple of times for debt, medical issues and benefits. I have depression and I find it difficult to deal with these things. My debts were going up, my benefits had stopped. My debts were going up because my benefits had stopped as well. I was very close to taking my own life because I couldn't see any other way. And now I've been to the CAB and they've helped me. I don't know of anywhere else I could have gone apart from my GP for help for my depression, and I would have continued on tablets for the rest of my life. Cost to the health service? Incalculable. Gentleman received help from the CAB for himself and his son who had learning difficulties. I'm 85 years old, I don't go out as I'm not in good health. My son can't read or write, but every time he goes to the Citizens Advice Bureau, he's told me. And I write to the CAB for help with my benefits and debt, and people come out to see me, and they help me get the money to which I'm entitled.
The Honourable Lady gave way.
Oh, well, give way.
Isn't the Honourable Lady making an excellent case for good general advice rather than necessarily legal advice? And isn't one of the problems with the way our system works is it incentivises more legal advice than general advice?
I would say that this advice is not legal advice. The person who'd been for help with a disability living allowance 3 times was going through an appeal. I'd been through 3 appeals. I'll give another case, which will demonstrate the issue that it's not general advice that is needed. In fact, a lone parent on income support was refused housing benefit as she was deemed to have a non-commercial tenancy under Regulation 9, paragraph 4 of the Housing Benefit Regulation. The landlord was her father. Without the rent, he was unable to make mortgage payments on the property. The mortgage company started court proceedings against the father. He had to start action to evict her, causing considerable family conflict, as you can imagine. After the CAB had considered the housing benefit regulations relating to non-commercial tenancies and the facts of the case, they concluded that the client's tenancy was commercial. The CAB helped the client submit an appeal, making representations based on the case of R. Mackay versus Barking and Dagenham, HBRB 2001 EWCA 234 HC. The Housing Benefit Department was unaware of this particular case and was persuaded by the arguments and representation the CAB made. It awarded the appropriate amount of housing benefit before the appeal was heard. As a result, the client could pay the rent, her father could pay the mortgage, a full appeal to an appeal tribunal was prevented, court proceedings were prevented that would have been instigated by the mortgage company, a homelessness application for rehousing from the client and the likely allocation of council property, and a full-scale family argument. Now, I don't know about you, but I certainly would not have known the case of R. Mackay versus Barking and Dagenham. And I don't believe that that is general advice. Yes, I will give way.
I'm very grateful for my honourable friend to give way. It's good to hear from someone who's had practical experience of dealing with people's problems, and I think what she is doing is demonstrating when people arrive at the citizens' advice, they don't just come with one thing, they come with about 4 or 5 different problems. Some of them could be dealt with, taking up the point earlier, with general advice, but it's crucial that they have access to legal advice as well if they're going to achieve some solution to their problems. What would be the problem? What would be the result if the legal element of that advice disappeared and people gave bad advice to people who had problems, who ended up making their situation even worse because they received poor advice rather than good legal advice?
I thank the honourable gentleman for that intervention. I think the implication would be that A, the advice agency would be sued, having more unnecessary court proceedings, and B, the wrong advice would actually lead the person down an even worse track. I do believe that there is an interesting distinction to be made between legal advice and quite detailed information about the law, and that is what the Legal Services Commission actually pays for in this case. It is very detailed information about the law. Now, I have used the Child Poverty Action Group's excellent books, and they are, more than one, and the one about the benefits section is that thick. Were it just general advice, I am sure we could compress it into a lot less. It is not general advice, it is extremely complex, going into a number of regulations and statutes.
Isn't that an argument for simplifying the benefits system? And does she agree with me? Does she agree with me that the way that legal advice has been provided in the past is not necessarily in the most cost-effective way? And through telephone advice and web-based advice, we could be serving people much more efficiently and avoid the so-called advice deserts that the other honourable members have mentioned.
I absolutely do not agree with the honourable lady on that point. I was working in Citizens Advice Bureau when the system changed from supplementary benefit to income support. The CPAG handbook started off probably about 1 inch thick. It's now developed into 3 inches thick because of the way the system developed, which is case law. As soon as a new system is brought in, the number of appeals absolutely rocket. Now, the honourable lady, I'm sure, will agree with me, the system has not got any more complex over the last year, and yet the number of appeals on incapacity benefit and ESA have gone up by 167% in the last year alone. So what they are likely to be when the new system comes in, I cannot bear to imagine. 50% of those appeals on incapacity benefit and 38% of those appeals for ESA were actually decided in favour of the appellant. The cost of those appeals, actually, in terms of the legal advice provided, was £167.
I'm very grateful to my honourable friend for giving way. She hasn't dealt with the second point, but I hope that she will, about the idea that you can actually replace good legal advice with some sort of hotline or some sort of computer program. I hope she will agree with me that the people who turn up for this advice are often people that can't either communicate as effectively as they would like, and secondly, haven't got access to a computer.
I'd absolutely agree, and I would refer the honourable lady to the answer given by Steve Hines in our evidence session, number 4, where he stated that the people who are most likely to need the legal system are those in groups D and E, who are less likely to have access to a mobile telephone or the internet. And I think his actual phrase was, if you want to create a system that stops the people who need it using the advice, this is the way to do it.
Absolutely.
In fact, I have a case from someone who said that they had wronged the benefits agency and had actually received no help from them whatsoever, and that the actual fact of picking up the phone had nearly put her off going for face-to-face advice. She could not face picking up another telephone to speak to somebody in a call centre. What she needed was somebody to pick up how distressed she was from the case that she had and from not receiving her benefits. Telephone advice is good in some circumstances. I think we all want to increase access to telephone advice, but it is totally unsuitable for a number of the vulnerable people with learning disabilities or who are actually in a state where they are almost at the end of their tether and suicidal, as the examples I gave earlier.
Will my honourable, I'm grateful to my honourable friend for giving way. She's making a powerful case. Does she agree with me that another group of people who are extremely disadvantaged by these long-distance systems are people who cannot read and people who cannot put together the information and the papers which they have in a coherent order, so they can't answer questions on a web-based system because they can't do the arithmetic, they don't know what the numbers mean?
I absolutely agree. There are a number of clients, and I'm sure we have an amendment later that goes through the availability of telephone advice and the suitability for all clients. But I will also refer them to the answers given by all of the 4 people who came to give evidence in the evidence sessions, who, when I asked at a very brief time, because we were due to finish, whether they thought telephone advice was suitable for all their clients, said absolutely not.
I wonder if I'm grateful to my honourable friend. Has you also had the same experience as I have with the change to actually a hotline with the benefits agency, where someone will actually ring up the benefits agency and they will get the same person or a different person in town, they'll get different advice every time. And quite frankly, they end up with a citizens' advice bureau or an our surgery, because the system that they want to put in place for legal aid or replacement of legal aid is going to be exactly the same system that you've got for the benefits.
Yeah, I have great concerns about the gatekeepers of the system and the people providing the system being gatekeepers of the system. There are also people who have no access to a telephone or a web at all. We had clients who were in secure units who couldn't speak on a telephone privately about their benefits. Where would those people get advice if that was the only means that they could get advice on the system? It is difficult to quantify, but I believe that some of these cases actually demonstrate that the wider cost to society and that the wider costs to the state will actually be increased if we remove access to social welfare law at an early stage.
Carl Turner. Thank you very much.
Indeed, Mr Osborne, I'm conscious of the time, so I'll be as quick as I possibly can be. But I rise to speak to the amendment in my name, Amendment 14. It proposes Clause 1, page 1, line 8, to insert, for the purposes of securing practical and effective access to justice for individuals. Schedule 5, paragraph 49 of the bill removes section 1 to 26 and schedules 1 to 3A of the Access to Justice Act 1999. This removes the duty of the government to ensure that individuals have access to legal services which effectively meet their needs. Mr Osborne, the amendment would reinstate this important duty and remove any doubt that the Lord Chancellor will ensure that those who need legal assistance do not go without. As I've said, Mr Osborne, the amendment reinstates the duty that already exists under the current legislation. I think this is a very important duty. The amendment, if accepted by the government, absolutely puts to bed any suggestion that the Lord Chancellor will renege, or fail rather, in his duty to provide legal assistance to those who need it. It seeks to ensure that our constituents continue to receive practical and effective access to justice. Practical and effective access to justice means that when people need access to legal services and legal professionals, it will be effective advice and assistance that they receive. It's not, it doesn't mean a telephone call, an opportunity to speak to someone on the end of a telephone line. It's about proper, effective access to justice. Of course, I give way to my honourable friend.
I've complimented on moving, I think it's an important amendment, and to make a point that I was trying to make, but I think probably making it more succinctly, which is to say that the which is to say that where the Access to Justice Act was inclusive, It gave a whole raft of powers and responsibilities to the Lord Chancellor. This is, in one fell swoop, taking that away. And what his amendment does, very cleverly, I think, I don't know if you agree with me on this, puts back that responsibility so the Lord Chancellor cannot abdicate his responsibilities.
Absolutely. Very obliged to my honourable friend from the front bench. He's absolutely right. That's exactly what the amendment seeks to do. And honourable members on this side of the committee have real concerns about what the agenda of the government is, I think. It brings me, I think, to another point. There seems to be, and I think it's been mentioned already in the committee, but there seems to be a myth that publicly funded lawyers have earned fortunes and continue to earn fortunes. The honourable member for South West Norfolk made the point in an intervention not so many minutes ago in relation to what lawyers earn. Well, I can tell the committee that publicly funded lawyers don't earn as much as I suspect the honourable member thinks they do. I'm guessing, I don't know for sure, but I suspect a solicitor who's probably got something like 4 or 5 years post-qualification earns in the region of probably £30,000. I wouldn't expect them to earn more than that. They are qualified lawyers. They have done lots of exams and passed those exams, probably duty qualified solicitors if they work as criminal solicitors. They are very likely to have higher rights of audience in court, so they will be expensive for their firms to train and continue to employ. Of course, they'll need to do the requirements of CPD points and so on. I make that point because there seems to be a suggestion that not only are publicly funded lawyers doing very well from the current system, but the firms of solicitors earn fortunes as well. It's just simply not the truth. I've digressed a little bit.
On that point?
Yes.
Would you agree with me? Does you find it strange that the opposite benches seem to be very concerned about people working in family practice law, but they don't have any regard whatsoever for those at the very top, those barristers and expensive lawyers at the top doing criminal law? They seem quite happy that the public pay should keep on paying such large fees to that group.
Well, my honourable friend makes a very valid point. It does seem that the government are concentrating their attention at the low end of the profession. I've got great concerns. I think the government, Mr Oliborn, have ignored thousands of responses to the proposals. If legal aid is withdrawn from substantial areas of law, many people will be disenfranchised from the justice system. Will be left unable to access justice and to enforce their legal rights. Without the benefit of proper legal representation, people will be left with no choice but to paddle their own canoe, take on the system on their own. It's very, very often, Mr Oliborn, very difficult, complex, procedurally and legally law. And this is why I think the Bar Council very accurately describe the government's plans as do-it-yourself justice rather than access to justice. I don't look at the Bar Council, or the Law Society for that matter, as some trade union. There seems to be a suggestion from the Honourable Member for Ipswich that's exactly what they are. Even if they are a trade union representing the interests of the members, they're not, as I suspect he would have us believe, some left-wing firebrand trade union. I've not read the article, I have to say, which he wrote for the Times newspaper. I shall do after this committee, but I suspect that's what he was suggesting in that article. Of course I'll give way.
Thank you. I think I made a suggestion that they were left-wing or firebrand, and not necessarily those derogatory terms. But it is worth pointing out that the President of the Law Society wrote a preface to a report by the Haldane Society for Socialist Lawyers. Socialist lawyers, that's a word that members' offices used to use a few decades ago, saying it was fair and balanced, and it evidently wasn't. And that really is the position we're having now from the Law Society. It is not a fair or balanced organisation, and it is not an opinion I think we should take as if it is the unvarnished truth.
I'm conscious of the time. I'm going to move on, Mr. Oliborn. It's safe to say I disagree with the intervention of the Honourable Gentleman. I'm always entertained by the Honourable Gentleman, but I tend to disagree with him for the most part. I've got other concerns as well, and I think honourable members on this committee would agree with me when I talk about the disruption and costly delay to the court system, which the proposals I think will create. This is an issue which was raised by the Bar Council and the Law Society, and I think I'm right in saying the Judges Council of England and Wales. And it worries me, Mr. Oliborn, that we seem to have a situation whereby professional bodies such as the Bar Council and the Law Society, and indeed the Judges Council of England and Wales, are ignored by this government. I think there was something of the order of 5,000 submissions in relation to the consultation on legal aid, and it seems the government didn't really listen to those submissions. It's worse still, I think, that the government seemed to have ignored their own research. I think I'm right in saying that they spent time in researching the issue of the plans and whether it would cause more litigants in person. I think the finding was that actually it would, and that this would cause considerable delays and considerable costs to the system. But of course, they've chosen to ignore their own, as I've said, their own research into this area, which is a great concern to me. I've, Mr. Oliborn, just come off, I'm pleased to say, delighted to say, in fact, the Health and Social Care Bill Committee. It was a recommitted Bill Committee, recommitted because the government spent several months saying very little to people like me when I made comments and remarks and speeches in the Bill Committee. They decided to slap to one side the submissions made by honourable members from my party, ignored them, and then all of a sudden decided that they would listen. I'm very grateful, Mr. Oliborn, for the indication. I suspect I'm going slightly off track, but the point I make is I think, a very valid one. The need to listen to the submissions that are being made by the professional bodies. The Bar Council, the Law Society, the Judges Council of England and Wales made very strong submissions about the consequences of these provisions. The amendment, as I've said, Mr. Oliborn, simply reinstates the important duty that already exists and removes any doubt that the Lord Chancellor will ensure that those in need of legal assistance do not go without it. If the government are serious about wanting to retain access to justice, then this amendment helps them in their endeavour. With that said, I would urge honourable members to support the amendment. I'll indicate to you now, Mr. Oliborn, that I will be pushing that amendment to a vote.
It seems somewhat strange, Mr. Chairman, to be addressing the committee for the first time after some 5 hours of deliberations, but let me welcome you to the chair. Let me say to start off with that I was pleased to hear the cooperative tone suggested by the Honourable Member for Hammersmith, and I do hope that we can move through this bill with due consideration, but also with an urgency that our legal aid system requires, but I have to say was somewhat lacking in the Honourable Member's approach to date. We had many good contributions, many knowledgeable comments from Honourable Members on both sides. It was a very lengthy debate, let's be frank, so let me move straight now to address the amendments. And these proposed amendments seek to address and amend Clause 1 to include express reference to the need to promote and ensure access to justice. And if I could firstly point out that the Honourable Member for Hammersmith referred to the purpose of the bill being ignored, and I would just say that that is not the case. Clause 1.1 says that the Lord Chancellor must secure that legal aid is made available in accordance with this part, so it's quite clear what the purpose of the bill is, and we don't actually need a purpose clause. Amendments 60, 14 and 61 in new Clause 1 all seek to introduce a requirement for legal aid to ensure access to justice for individuals. Mr. Chairman, I acknowledge the vital importance of protecting fundamental rights of access to justice, and this has been central, I can assure all honourable members, in developing our proposals for reform. Fundamental rights to access to justice are the subject of international protections, such as through the European Convention on Human Rights and certain enforceable EU rights. I'm confident that the plans set forward in this bill protect those fundamental rights through both the areas retained within Scope and Schedule 1 and also through the new exceptional funding scheme.
To give way. He says that his first priority was to maintain access to justice. Given the fact that he agreed to substantial cuts in the legal aid budget, isn't it a question of fitting the new policy, the new bill, around the money that's left after he's accepted the cuts?
I did say that our first priority was to retain access to justice. I said that we took on board the fundamental rights of access to justice. This scheme will ensure that in individual cases where the failure to provide legal aid would be likely to amount to a breach of an individual rights under the Human Rights Act 1998 or European law, exceptional funding for that individual will be available. This is a vital safeguard for ensuring that no one will be deprived of their fundamental rights of access to justice. We live, however, in a difficult time of scarce resources. As the Honourable Members for Kingston upon Hull East, he acknowledged it, and as my Honourable friends for Erewash and Ipswich advocated very plainly, it is essential that we achieve an affordable system for legal aid which allows for taxpayer-funded representation to be targeted on priority areas, and we made clear that in our consultation paper. It is not the case, and indeed it has never been the case, that everyone is entitled to legal representation provided by the taxpayer for any dispute. It is essential that we are able to put forward reforms that establish an affordable system while still ensuring that no one is denied their fundamental rights of access to justice. The Honourable Member for Hammersmith said, "I think we know what we mean when talking of access to justice." But I ask the question, do we? Is it the absolute terms that he seemed to suggest in some of his remarks? Or is it, as is used in the Labour flagship Access to Justice Act of 1999? Mr. Chairman, it is important to clarify that despite its name, the Access to Justice Act 1999 of the previous administration does not contain an equivalent duty to that put forward by the Honourable Member. Indeed, there is no, and nor has there ever been, an express duty on the Lord Chancellor or Legal Services Commission to secure access to justice. Perhaps one of the members opposite may wish to advise the committee why the last Act was so named. The 99 Act only requires that the Legal Services Commission establish the community legal service for the purpose of securing, within the resources available and the priorities set, that individuals have access to services that effectively meet their needs. This concept was debated very skillfully by my honourable friend for South Swindon in his earlier remarks. In any event, the common law right of access to justice does not guarantee legal representation or equality of arms. While it is clear that a fundamental principle of law is that every citizen has a right of unimpeded access to a court, this does not include a right in all circumstances to receive advice from a legal representative. A right of access to the court means having the assistance of the court to assert legal rights and obtain remedies which you are entitled to. It means having the right to challenge a decision in the courts if you wish to do so. It means not preventing you from issuing court proceedings because of an inability to pay the court fee. All of this is despite the point rightly made by my honourable friends for Broxtowe and error wash that too often people rush to lawyers and court when they should be using alternatives. Now, during the remarks made by the Honourable Member for Hammersmith, he mentioned the question of impact assessments and the certain possible outcomes that were stated in the impact assessment for this bill. And firstly, can I say that I'm very pleased that he reminded the committee that we have looked carefully at the possible outcomes in those impact assessments. But let me say to him that it is right and proper to consider all risks and possible eventualities. However, this does not make them either likely or probable. All impacts will be determined by behavioural responses. These cannot be predicted. Hence, we need to discuss all risks. And this is called analytical rigour. And the Honourable Member is unwise to disparage those in the way that he did.
I will. That sounded like a disclaimer at the end of a mortgage advert to me. And I prefer his previous comments. Legal aid per se involves poor people, so if we're going to reduce costs, it will impact on poor people. It's true that individuals with protected equality characteristics are overrepresented in the current client base of civil and family legal aid when compared with the population as a whole, although the extent of that varies by category of law. That's what the minister actually means, doesn't it? It means that he's cutting a service which goes to poor people, therefore poor people will suffer.
No, what I'm actually saying is that the impact assessment looks at a range of impacts so that people can take a valid decision on the possibilities of policy reform. So, various examples have been given this afternoon. The main example and the main debate focused on clinical negligence. And so I'm actually going to address, and a lot of points were made by a lot of honourable members on this, particularly the Honourable Member for Hammersmith, and I think St Helens North made a number of comments. So let me take this and go through the issue here. Currently, legal aid is available to those who qualify financially and who have suffered negligent medical treatment to seek damages against any type of public or private medical practitioners. While these are claims for monetary compensation, we consider they often raise very serious issues, especially whether damages are required to meet future needs, and some litigants will be vulnerable because of disabilities resulting from the negligent treatment. However, although the issues raised are likely to be very important, we consider that there is a viable source of alternative funding to legal aid in CFAs, which are more readily available in such cases than for other claims. We therefore consider that legal aid is not justified in these cases and that our limited funding would be better targeted at other priority areas, such as those concerning physical safety, liberty or homelessness. And the Honourable Member for St Helens North, if I may actually answer his first questions, then he might have some more. But taken with the Jackson proposals was the point that he actually made earlier. He asked, wouldn't that leave a number of claimants without representation? Now, we recognise that there will be some particular cases where it may be difficult to secure CFAs, but our proposals would ensure that individual cases of this type continue to receive legal aid where necessary for the UK to meet its international and domestic legal obligations via a proposed scheme for excluded cases. It is also intended that the reform following the Jackson proposals will provide for a tightly drawn-up power, allowing recoverability of ATE premiums in clinical negligence claims. Does he wish to make an intervention?
Yes, I'm grateful to the Minister for giving way. I think the first point is that he seems to ignore the evidence that we heard last week, which seemed to indicate that the practitioners believe that these sorts of cases are very expensive. They often have £100,000 to £200,000 upfront costs, that it's unlikely that companies will take them, and even if they do, they will limit the number of cases they take because of the liability to their own company. And I wonder if the Minister could spell out what the discretion will be for the judge for those people who find themselves without legal redress that need to find a way through the courts to actually take a case.
The reason why I'm not going to today is because we have a clause in the bill specifically dealing with excluded cases. And it is an area, it is a very full and particular area, and we will be going through it in some detail. And I can assure the honourable gentleman that I will cover the comments he's just made very carefully when we come to that clause. And with the time that we have, I think I should keep moving on today. Turning to the other aspects of Amendment 61, Mr. Chairman, Under Amendment 61, the Lord Chancellor would be required in carrying out his functions to protect and promote the public interest and support the constitutional principle of the rule of law. The amendments are unnecessary, Mr. Chairman. These considerations are inherent in the Lord Chancellor's functions as a Minister of the Crown and do not require specific reference here. In addition, the Lord Chancellor has some specific duties under the Constitutional Reform Act 2005. The proposed new subsections 7 and 8 of Amendment 61 are also unnecessary, as they seek a statutory footing for a legal aid strategy. Mr. Chairman, the bill before us at this moment is precisely that. The bill is the culmination of an extensive consultation and engagement exercise which sought to define the nature and range of legal aid services in the future. We have been clear on the objectives of the new scheme throughout the process. We have also undertaken to conduct a post-implementation review of the new scheme, which will be published. And of course, the House will be free to debate its findings. Accordingly, Mr. Chairman, we believe that this amendment is unnecessary. Turning to the proposed new subsections 9 and 10 of Amendment 61, the practical implications of these makes them administratively impossible to achieve. Trying to establish what drives the cost in the wider justice system and the links between that and the welfare system and the reforms to legal aid would be very difficult. And I also do not think that it would produce any meaningful results. I do not accept that there is a need to create accounting functions. The relevant financial information in relation to the agency will be included in the annual MOJ report that deals with the Department's finances, and there is no precedent for this in any area of government. Mr. Chairman, I would like to deal with the remaining aspects of the new clause put forward by the Honourable Member for Hammersmith, which I have not yet addressed. The first is the proposed principle that the constitutional right to be regarded as innocent until proven guilty should be respected as the cardinal principle of criminal law. Mr. Chairman, it goes without saying that of course we agree with the fundamental principle of innocent until proven guilty. It is not, however, necessary to include it as a principle on the face of the bill. We have made it absolutely clear throughout this reform process that we are not proposing to make any alterations in respect of the scope of criminal legal aid. The last element of the proposed new clause, dealing with the availability of resources, is, we believe, equally unnecessary. I have to say that I'm a little surprised, as I believe was my honourable friend from Ipswich, that the honourable member puts forward such a proposal in the current fiscal climate. To answer his question on financial accountability in opposition, yes, the Conservative front benches in opposition were expected to clear all spending commitments with shadow Treasury colleagues. This is known, I believe, as responsible opposition, and I'm surprised that the opposition front bench can issue uncapped spending commitments. To address the issue made by the Honourable Member St Helens, as we have made clear in our proposals in the consultation document and in bringing forward this bill, legal aid resources are not infinite, and we have taken the hard choices necessary to target that finite resource where it is most needed. Turning to Amendment 89, tabled by the Honourable Member for Stretford and Urmston to Clause 1, this amendment would require that before any changes to legal aid are made, a full independent assessment of any likely increase in litigants in person and the consequent effect on the deficit would have to be undertaken. Mr. Chairman, we believe this amendment to be unnecessary. We conducted a full review of the available literature on litigants in person, which was published alongside the consultation response. Various members, the Honourable Member for Hammersmith and I think Bishop's Auckland, asked how claimants are expected to prepare their own tribunal applications in this context. And in most cases, individuals will be able to appeal to the first-tier Social Security and Child Support Tribunal without formal legal assistance. The appellant is required only to provide reasons for disagreeing with the decision in plain language. For those who need assistance on a welfare benefits matter, there is factual advice available from, for example, Job Centre Plus, the Benefits Inquiry Line, and the Tribunal itself. And I'm pleased to advise the Honourable Member for Makerfield that in the example she gave, the CAB example, where CAB gave legal advice to stop the client's eviction, I have to say to her that that will be remaining in scope. Mr Chairman, litigants in person are already, as the Honourable Member for Stretford noted, and have always been, a feature of our legal system. We accept that the reforms will mean an increase in unrepresented litigants, and that this may impact on case duration. The important point here is that there will also be significantly increased numbers not going to court at all. My honourable friend for Ipswich spoke persuasively in support of mediation. We think that there will be at least an extra 10,000 cases of mediation, and we are not in any way going to cap those numbers. This is likely to help offset any additional burden on the courts, and should mean that they are still able to deal effectively with cases they do see. And I can confirm to my right honourable friend for Carshalton that the government does have a significant project to extend mediation within government, and we are also doing work with local government to extend mediation within local government. He is right that government should be leading the way on this, and we intend to do so. Several honourable members queried the relationship between mediation and legal advice, and I can tell them that once a funded mediation client starts mediation, there will be legal advice at the legal help level on a fixed fee basis. We recognise, as the Honourable Member for Hammersmith pointed out, that people do now, and they will, after this legislation still, find the justice system daunting and difficult to navigate, and that they may need help with this. This is an area that we agree has been ignored for too long, and the government has a number of plans to simplify the system, such as through the Family Justice Review. There is also a range of work going on to produce better guidance, to simplify forms and rules, and to create online walkthroughs. There will also be post-implementation reviews of the reforms. Turning to the Honourable Member for Stretford's other amendment, Amendment 83, this would require the Lord Chancellor to ensure that no areas of law that are currently within scope can be removed until there has been a full independent assessment as to costs, and the assessment reasonably establishes that the removal will not increase the deficit. The assessment must be presented to Parliament. We believe that this too is an unnecessary amendment, Mr Chairman. The clear goals of our reform are to discourage unnecessary and adversarial litigation at public expense, to target legal aid to those who need it most, to make substantial savings to the cost of the scheme, and to deliver better value for money to the taxpayer. As we have made clear from the outset, a cultural and therefore behavioural change is one of the key objectives of the reform programme. We are seeking to move away from adversarial and litigious resolution of disputes and instead promote greater use of alternative methods of dispute resolution and the right provision of advice and information to empower people to resolve their own problems. At the same time, the bill will ensure that legal aid is retained for the highest priority cases. I give way to my honourable friend.
He mentioned the amendment by the member for Stretford and Urmston, and in her point she discussed the division between immigration and asylum cases. And I also mentioned in my submission that there are some issues that we are concerned about on this side of the House, and it touches on that particular issue, actually. And that is that whilst asylum will remain in scope and non-detention immigration will be taken out of scope, is there not a possible problem with those suffering domestic violence who are involved in an immigration case, who will automatically be taken, therefore, out of scope? And would it be possible for the government, therefore, to review that particular area in the way that is done on domestic violence elsewhere in the bill?
My honourable friend makes a very good point, and let me say that the inclusion of cases brought under the immigration domestic violence rule within the scope of civil legal aid was raised a great deal during the consultation, and we considered the point carefully. Whilst we accepted that the applicants in these cases were vulnerable, we did not think, on balance, that legal aid was required. Essentially, this was because the applications were paper-based ones, similar to other immigration applications. We did, however, recognise that people might need assistance obtaining the required documentary evidence, but considered that this assistance need not be specialist legal assistance funded by legal aid. However, following further consideration, we accept that these cases are very unusual. There is a real risk that without legal aid, people will stay trapped in abusive relationships for fear of jeopardising their immigration status. The type of trauma that they may have suffered will often make it very difficult to cope with this type of application. We also appreciate that people apply under great pressure of time, and of course access to a properly designated immigration advisor is also a factor. We intend to table a government amendment to bring these cases into scope at a later stage, and I hope you'll be pleased with that response. We recognise the concerns of some that early legal advice may reduce the costs further down the road. However, we consider that our approach to prioritise cases where life or liberty is at stake, or there is a direct and immediate risk of homelessness, is rational and appropriate, and indeed necessary to ensure a sustainable system for legal aid. And the honourable members for Makerfield and Stockton North spoke about early intervention being essential. And I can say that we listened carefully to the points made about the importance of early advice in social welfare cases. However, given the need to make substantial financial savings within the spending review period and to target resources on those who need them most, we consider that debt and housing cases where there is an immediate risk of homelessness is the appropriate priority. Overall, we consider that financial issues, however important to the individual, are less important in terms of legal aid funding than fundamental issues such as safety or liberty. We also consider that many of these cases are about practical rather than legal problems. Therefore, whilst we recognise that advice on money management is often of clear benefit to the client, it is not necessarily an issue which requires specialist legal advice funded by legal aid. We recognise that many respondents told us that other sources of advice will no longer be available in the future. However, on 12th of February of this year, the government announced continued funding of £27 million to maintain the face-to-face debt advice programme in CABs and other independent advice agencies across England and Wales. So, on early advice, I will.
The Minister accepts that currently the face-to-face funding will finish actually in 2012 March, where the legal aid cuts will come into operation in 2013, so it won't be available.
Well, I'm going to come on to the other things that are available, but of course this is money which will need to be discussed as to how it's going to be applied or whether it's going to be available for future years. I agree, and that's been made quite clear. So early on, let me be clear that I agree with the argument that many people with disputes or grievances need early, good quality general advice, and not necessarily the expertise of specialist lawyers. Of course, I can see the points made by honourable members, and intuitively, some early advice may well have a preventative benefit in relation to avoiding downstream costs. However, changes to legal aid alone shouldn't of themselves undermine the provision of general advice. As a matter of principle, legal aid is money that has been intended for specialist advice, not cross-subsidising other activities. As a matter of practice, legal aid only represents one of several income streams for many organisations. For example, with 85% of CAB's funding coming from other sources, with half of all Bureau getting no legal aid funding at all. The following question was, how did the government expect the not-for-profit sector to fill the gap left by the reforms? And I can say here that the government recognises the important role that not-for-profits such as CAB play in delivering advice services at local level. We are considering the impact of wider reductions in their funding, recognising that legal aid represents one of several income streams for many organisations. The government is reviewing the likely impact on not-for-profit advice organisations to identify the scale of the issues and to consider the appropriate role for government in contributing to the future sustainability of the sector. At second reading of the bill, the Lord Chancellor announced that government will be providing additional funding to the not-for-profit advice sector in 2011-12. This will amount to an additional £20 million. This is, of course, in addition to the £100 million of transitional fund made available last December. We are also mindful of the impact of reforms beyond this financial year, as the Honourable Lady quite rightly said, and the review will consider the issues this creates. The Honourable Member for Hammersmith mentioned his local law centre, which had a 100% cut from his local authority. I'm pleased to say that Huntingdonshire CABs have not been cut. I'm sure it's got nothing to do with the influence of the local MP. My right honourable friend Carl Shulton quite rightly said that the picture was mixed across the country. and the Honourable Member for St Helens North also remarked on this issue. I can tell honourable members that the average across CABs, to give a representative not-for-profit organisation, is about a 10% average cut across the country. This is similar, of course, if not better, than the cuts happening in the public sector. Although I would advise caution on this figure, as I've said before, most CABs would have more funding streams than just the local authority. And that point was made by the Honourable Member for Makerfield in her earlier remarks. Amendment 83 is asking us to predict the future benefits and costs of these reforms. This is notoriously difficult to achieve, as the extent of any systemic costs arising will be driven by a range of factors which are difficult to predict, including an individual's behavioural responses to the changes which we are seeking to make under this bill. Nevertheless, we have given careful consideration to this issue as part of the policy development and clearance process. Extensive discussions between policy officials of different departments were held as part of this, and clearly, knock-on or downstream costs were factored into those discussions, as well as being part of the consideration given by the Home Affairs Cabinet Subcommittee in agreeing to the proposals. The Honourable Member for Stretford also made the point that welfare reforms would mean that legal aid must be maintained for these matters while reforms are bedded down. And I can say to her that there are a number of proposals currently being considered across government that should make it easier for people to receive the right provision or entitlement in areas such as welfare benefits and education. The most notable of these is universal credit, which will help reduce the scope of fraud and error as it makes the whole benefit system simpler and easier to understand. But I will.
To the Minister, we naturally all hope that will be the eventual outcome from the introduction of universal credit, but my point was very specifically about the transition to universal credit, which will be protracted, will leave people unsure if they're in the new system or the old system, and needing to understand how they will transition across. It was specifically in relation to that I was querying whether there could be extra support.
The Honourable Member made a very fair point, and I can assure her that ministers spend no little time meeting with each other across departments to address this very issue and to see how we can make the transition as smooth as possible. But I can also confirm to her that we shall continue to be reviewing costs, and this is a point also made by my right honourable friend for Carshalton, who asked how we propose to review progress of our reforms, and I can confirm to both of them that firstly we are now exploring client and provider research to be conducted in the near future. That would be this year, of course, before the commencement of the bill. And secondly, that there will be a post-implementation review to be conducted 3 to 5 years after implementation. Accordingly, we do believe that these amendments are unnecessary, and I urge the Honourable Member to withdraw them.
Yeah.
Thank you, Mr. Holloway. I think there's been an excellent debate, which justifies the high bar I set for the committee at the beginning of proceedings, but I also think it justifies the debate, which has been a general debate in part on the issue of legal aid and where it stands in its history, but also has related specifically to some of the provisions in this bill. Honourable for Carshalton and Wallington, or the right honourable for Carshalton and Wallington, made his "What would the Labour Party do?" speech, which is his default speech now. But I like to think of it as his conscience pricking him as he contemplates making yet more cuts. Honourable the member for Hull East had 2 bites of the cherry. First, talking movingly, I thought about his personal experience, but using it to illustrate that the truculence that there can be amongst some defendants, including and particularly sometimes with the NHS, the lack of willingness to admit fault by clinicians within the NHS, and the idea that proper redress can be had by those who have suffered clinical negligence or indeed other injuries at the hands of the NHS and other public bodies without the availability of legal aid or no win, no fee, I think is something that the government needs to come back to us on. And then he also, in moving his amendment, talked about the filleting, I paraphrase, of the AJA, of the Access to Justice Act, and the fact that the government should not be allowed to get away with that, and they should have further obligations. A speech I agreed almost entirely with the member from Swindon South. Certainly his history of legal aid and indeed some of the alternative solutions he proposed. The only point I didn't agree with him on is in, again I paraphrase, to say that it was something of a storm in a teacup to say that the proposals in this bill would in some way undermine the legal aid system we have here. Well, I think the 5,000 responses that there were to the legal aid consultation say different from that. And what those responses say, from a whole raft of organisations, but very learned and engaged and committed organisations on the whole, this is a profound change, and I wouldn't want to lose that point. My old friend, the member for Streatham and Urmston, moved two very persuasive amendments. I don't know how far they persuaded the members opposite. I don't think we'll find out today necessarily as they come further down the amendment paper, but I think both in relation to costs and also in relation to litigants in person, they are, in my mind, unarguable points. We will see how far they are true, how far the courts are clogged up, how far justice is not done with the absence of lawyers, and how far other parts of the state or individuals themselves have to bear the cost of lack of representation. But I think even at this stage it's unarguable that there will be those costs and those delays and those problems. I say, and I don't want to fall out with the Honourable Member for Ipswich, but I thought it was a speech that was a bit too clever by half. I think to say that you can't spend to save in a bill where payment by result is at the heart of the reform of the criminal justice system is a bit bizarre. And I say, I wince slightly when members use words like lying and malicious in committee. I think he may want to reflect on the use of those terms. I know what he's referring to. He's referring to my constituency. I don't particularly take personal umbrage at that. I've been in Hamilton's politics for 30 years, and they're quite mild terms in that milieu. But I do take some exception to the fact that he thinks he knows better about what's going on in my constituency, but very, very serious matters to do with people's homes are occurring this week, as I indicated. I won't digress by getting to that subject, but I would just say it's not a proper place to go, either in this Bill Committee or I would have thought from his perspective, knowing very little or anything about the area. Alderman for Makefield made her points very succinctly and very clearly by use of example, and I think that they were all the better for that. And I conclude just by saying to the Minister that it is a bit like Groundhog Day, listening to the Minister sometimes, and I've given him points for doggedness, which is to say we hear the same things coming back time and time again, and I'll keep trying to wear him down, and maybe I'll get there in the end. All I would say is that he may be right that there has not been a clear statement so far within even the landmark bills that we've talked about today. But I think the spirit and intention of those bills was clear, certainly of the 49 bill, and I invite him to read the second reading debates in either house, and even in the 99 bill as well, as to what the intention of the legislators were on those occasions. And the reason why we feel it's important to put these amendments, one or two of them at least, to the vote, and to invite the government to support us, because we believe that for the first time that consensus is being broken, and that what the government intends to do is moving far away from the spirit which we intended. And I also say, in relation to finance, I think the Minister well understands the point that we're making. Yes, this is an area very clearly, we were before the election, as well as after the election, we said we would make cuts. And we do not resolve from the fact there's deficit to be dealt with, or the fact there will be cuts in legal aid. What we object to about the way that the cuts are being made here is they are being made irrespective and regardless of the service that is being offered. That is the problem here. That is the problem. And effectively, in many areas, we will have no service. But that point is not addressed. And to that extent, that is disingenuous. It's disingenuous for the government to say, on the one hand, that we're making cuts because cuts have to be made, but we believe in preserving a legal aid system, but leaving something which is well, not fit for purpose, to put it at its mildest. So I conclude, and I'm sure all members will be pleased, I will conclude on that point, and we come to voting, and you'll excuse me, Mr. Alderman, I'm something of a novice at this. I understand...
He'll explain it.
He'll explain it to me, but just to indicate, I feel in my bones that Arnold Friend Sir Halley is not keen to move his amendment. I would seek to move new clause 1, but I understand that comes later. My old friend Sir Mercer will wish to move one of hers. I understand that comes later. So from my point of view, the only amendment I would wish to move presently is Amendment 60, and I withdraw Amendment 61.
Amendment 60 proposed as on the amendment paper. The question is that the amendment be made. As many as are of that opinion say aye. Aye. To the contrary, no. No. Aye. Division. Aye. Lock the doors.
Mr. Crispin Blunt?
No.
Tom Brake?
No.
Robert Buckland?
No.
Alex Cunningham?
Aye.
Mr. Janobin?
No.
Yvonne Favag?
Aye.
Helen Goodman?
Aye.
Kate Green?
Aye.
Ben Gummer?
No.
Damien Hines?
No.
Jonathan Reynolds?
Aye.
Mr. Slaughter?
Aye.
Anna Soubry? No. Elizabeth Truss?
No.
Carl Turner?
Aye.
Mr. Wallace?
No.
Mr. Watts?
Aye.
Mr. Wright?
No.
They're voted in that division ayes 8, noes 10, so the noes have it, unlock.
I beg to move further consideration of the bill be now adjourned.
The question is that further debate be now adjourned. As many as are of that opinion say aye. Aye. Of the contrary, no. I think the ayes have it. The ayes have it. Order. Order.
Thank you.
Great.